tribunal ଅଛି on WPC lordship for yesterday matter was there lordship after hearing the matter this is to 13th January lordship. I have filed two IH. One is for preponing the date fixed for hearing and admission, and another is the my lords for a stay of revival order of the termination lordship.
You don't know, you give what it is.
On Monday I pray lordship
CRL
because lordship
Please give it.
827
I pray for Monday lordship.
I have filed an IA for extension of surrender date.
Give it to you.
Current mention lordship on fresh admission lordship. It was 14 matter admitted in lordship.
Six similar matter, I pray both the matter may be taken up Monday.
You want adjournment of item number 6.
Both the matter are similar, ma'am.
No, any case has been disposed of earlier.
No, ma'am.
So it will be disposed of today and that will be taken up on Monday. What is the problem?
My lordship, seeking pardon. My lords, we have filed 2 IA in the appeal, criminal appeal. The marriage of the sister has been fixed on the 3rd of the January. Lordship, he has suffered more than 13 years of custody. So, lordship, in
number,
that,
give the number just.
my lordship, I will file a memo today. I am obliged, lordship.
Pardon to mention, madam, decimal. One CRLA number 179 of 2014, my lord. The petitioner is a life sentence completely, my lord. Now his wife is suffering from cancer which and who is admitted on Apache hospital, my lord. Now is not taking any type of food, taking only liquid food. Kindly restrict to Monday, my lord. Or interim bill. I have already filed an interim.
What is the number of the criminal appeal? What is the number of the criminal appeal?
English
Leave it, yes. No. Yes, call the matter.
IA number 3203 of 2024.
Not IA, but the criminal appeal number, Lord and Counsel, we are asking you.
17 CRL number 179 2014, my lord.
Please tell once again.
79 of 2014, my lord.
No, there is some glitch. It is not audible.
It's not audible. You send the message to. There is a chatting.
But I am sending the memo, my lord.
You send it in the chat.
Lord. 79 of 2014.
Send the messages.
Supplemental list. Item number 1.
Receive item number 1 on behalf of Mr. Mohan. We taken after some. We taken after 1 week time.
After 1 week. Right. Is there any interim order? Or it is coming for the first time? All right. A mention is made on behalf of Mr. Aravinda Mahanti for adjournment put of this matter after vacation, holidays, Xmas holiday.
Item 2.
May please. The limited grievance of the petitioner may learn that he has already filed a original application for the Central Administrative Tribunal since more than 2 years, my lord. I have already filed counter, rejoinder, everything has been ready. It has not been disposed of in spite of repeated approaches to the tribunal, my lord. So a limited grievance, let a court to give direction.
No, if we entertain this type of thing, then there would be just a floodgate. We cannot open the floodgate, and so that everybody would come that let the original application would be disposed of. Why don't you file an application for expeditious hearing there?
Well, I have already approached so many times. You have already given series of dates.
You see,
I have already given it.
There are old cases, number one, and once we do that, then there would be problems.
So we are only on the rule 14.
We are just disposing of you file an application for that will be considered.
No, only give too much time to dispose of this.
Writ petition has been filed by the petitioners for a prayer for a direction to the London Central Administrative Tribunal, Cuttack Bench, Cuttack, to dispose of original application number 126 of 2022 on merit within a stipulated period. It is submitted by the Land and Council that the pleading is complete. The petitioner is at liberty to move an application for expeditious hearing before the Land and Tribunal, which will be taken into account in accordance with law. Accordingly, the writ petition is disposed of. Yes.
For appearance may be noted, my lord. That will do.
कहाँ ना लिखते हो अपन देख लीजिए
List दे दीजिए.
अच्छा अच्छा
Allocation Mr. Kashyap is there.
Annex 3 to be disposed of. Next.
Yes, your representation.
Similar order has been passed in connected case.
किसी change हो जाए लिख दीजिए
खाली ना change हो सब annex 3
सब बाकी सब ठीक है जी authority same
खाली पार्टी रो नाम
okay
Item 4.
The petition challenges the order dated 29/10/2024 by Annexer 5, passed by the OP number 3, my lord. The OP number 3 and 4 acquire a land for acquisition for expansion of NS 20, my lord. Dismissal of 13, my lord. Here, the property is not a public duty, my lord. The operating portion.
No. The in the operative portion,
no, page 66,
it has been
my lord.
mentioned that he lacks jurisdiction to consider the prayer of the petitioner, and the petitioner is free to hesitate his claim in the proper court of law. So that is the observation. So what was your prayer before
my lord, page 66, my lord.
But you are in dispute with the title of both the parties. How can it be decided by that authority?
No, but I have no title, my lord. Here the OP number 3 directed to deposit the acquisition money before the endowment commission, my lord. The DT is not a public DT.
No. Those aspects can only be gone into when evidence is laid before the court. No.
Page 66, my lord. On the face of
you read the entire order. Verification of records. Kindly read that order.
Operating portion
66.
Last
verification of orders. Verification of records.
Last para, my lord. May I please?
Yes. Last but one.
On the face of the record,
no.
the DT is public DT.
No. Verification of records. You read.
Stating that. Read it.
Verification of records reveals.
First read that. Verification of record.
Second paragraph.
Second paragraph. Verification of record reveals that the khata number 87, village Kuakia, which include the plot number 29, area 57 decimal, Kisam Gharawadi, out of which hectare 0.182, along with the assets thereon, has been acquired for the construction of NH20, stands recorded in name of the Sapta Gosai, Vijay Kuakia Marfat, Bhagavan Das, son of Dasarath Das, Banwali Devata, son of Nandu Devata, Sindhu Panda, son of Damodar Panda, Donai Panda, Ishwara Panda, son of Fakiri Panda of Chandipur. Award for the above land and assets has been passed in the name of the Sapta Gosai, Vijay Kuakia Marfat Sonyas Das, son of Dukhi Das, Ushtachandra Devata, Vishnu Devata, son of Mayadar Devata, Prabodh Devata, Subodh Devata, son of Maheshwar Devata, Padmanabha Panda, Samsundar Panda, son of Jairam Panda, Sarath Panda.
Just skip over the names and then come the successors of the recorded Marfat Das, reported by the field functionary. And the total amount is this much. Has been awarded towards compensation for the above land. Assets
and the assets there.
And the awarded amount has accorded the approval of the competent authority. Now you read it.
Therefore, on the face of the ROR, DT of Sri Sapta Gosai is a public DT. In view of instruction communication by the government, where in it has been instructed to deposit the compensation amount awarded in respect of any DT's property within the Commission of Endowment Odisha Bhubaneswar for disposal at his level. The Commission Endowment Odisha Bhubaneswar has been requested by letter dated dash and dash necessary instruction as to whether the compensation amount belonging to DT shall be paid to the Marfatdar or to the Commissioner Endowment Odisha. In response of the above letter, the Commissioner Endowment Odisha has intimated that amount details
Account details.
account details, my lord, to deposit said amount within the direction to the inspector of endowment to sign the voucher with his official seal. The above amount has not been transferred so far as due to non-turning of the inspector of endowment Jajpur till date, my lord. The OP number 3 directed to deposit said amount before the inspector of endowment commission. The DT is not a public DT, my lord. DT is a private DT, my lord. The property is purchased by the petitioner's father in the name of the DT, my lord. The second aspect, the total amount.
No, what you say, DT
is a public DT, my lord. No, it is a private DT.
He is a private DT.
My lord, private.
So, but the ROR reveals that it is a public DT.
ROR in name of the page 19, my lord. Sapta Gosai Vijay Nijava.
Have you got a declaration under section 41 of the Endowment Act?
Then
how can you say that?
Second aspect is the total 13 dismil has been acquired by the
if you have got a declaration under 41 of the Endowment Act, then only you can claim that it's a private DT. How
the
can
second aspect is 13 dismil has been acquired by the OP number 3, my lord. Only 4 dismil compensation money is awarded. Directed deposit the endowment. Total 13 dismil money has not been directed to deposit the endowment commission, my lord. There are out of 76 dismil, 13 dismil I'll show you.
So the assistant commissioner has power to decide the dispute that whether it is a
private
institution, public, so on so on so that is there. So that is why question has been put to you whether any such declaration has been made.
No, my lord.
Then the ROR reveals that it is a public DT. So how the money is to be given to you?
Then I will file 41 applications.
You are
here is my minor case. My case is
that reason why the it has been held that you should approach the appropriate court.
Yes.
And that is why it has been observed.
My second aspect is, my lord. So 13 dismil has been acquired by the property of DT, my lord. Here the opposite partner only directed the award of 4 dismil money, my lord. Total amount has not been directed deposit.
Your prayer is something else. Your prayer is to set aside that annexure, the rejection, that annexure 5.
My lord.
Right?
My lord.
And also to set aside opposite party. No, that is the annexure 5.
Yes, yes.
With the direction to release compensation in favor of the petition, total amount 13 dismil.
Nothing ambiguous. There is no illegality in that order. We are directing you to approve the petitioners.
13 dismil has not been awarded. Only 4 dismil has been awarded.
File this writ petition challenging the order dated 29/10/2024 of the opposite party number 3, Special Land Acquisition Officer, NH Land Acquisition Cell number 20 at Pradesh to Jaspur. Passed under Annexure 5 with a further direction to release the compensation amount in favor of the petitioner's deity of total acres shown 13 decimal, along with the construction value of the deity Sapto Gosai is not a public deity acquired by the opposite party. As the Sapto Gosai. So the averments have been taken in the writ petition that the petitioners acquired the property by way of Marfat Das, and such property has been recorded in favor of private DT along with other co-sharers, and the opposite party number 2 and 3 notified the land for acquisition and prepared a compensation roll by mentioning the name of awarded tenant, in which the name of the petitioner is not mentioned. It is stated that the petitioners are Marfadar of Sapto Gosai of Chandpur, and they challenge the wrong ROR published in the names of persons who are not Marfadars in civil suit number 296 of 2024, which is sub judice in the court of Clarence Civil Judge Senior Division Jajpur.
Can
Earlier, the petitioners approached this court in WPC number 18870 of 2024, which was disposed of on 27/8/2024, with a direction to the opposite party number 3 to consider the representation of the petitioners. And accordingly, the opposite party number 3 filed impugned order dated 29/10/2024 dispose of the representation, wherein after noting down the factual aspects and going through the written note of argument, it was observed as follows. Quote karibe, page 66 on the face of ROR. In view of the facts stated above, the petitioner are free to agitate his claim in proper court of law. CJM for the bracket for the land counsel for the petitioners submit that in view of the provision available under Odisha Hindu Religious Endowment Act 1951, the property in question can be declared by the assistant commissioner to be a private duty, and therefore the petitioner may be permitted to approach the appropriate authority in accordance with law. In view of such submission, the writ petition is disposed of, giving liberty to the petitioner to approach the appropriate authority. It is
petitioner grandfather
not expressed any opinion on the merits of the case. Yes, we don't find any illegality.
petitioner grandfather Sindhupana name is there in the
We give all those things detailed in that. If any such petition is filed within a period of 4 weeks from today, the same shall be considered expeditiously, preferably within a period of 3 months on the appearance of all the opposite parties, from the date of appearance of all the. Yeah.
Item 5.
Item 5. The petitioners are the railway employees, my lord. Earlier, Mr. Sanjeev Pai has filed this writ application, but he has been appointed as a state counsel. So I have filed my appearance memo on 28/11. I may be permitted to place this matter.
What is your appearance memo?
Appearance has not been come. Asin 28/11 file kaleeni.
Is there any urgency?
Urgency, my lord, because though the order, your lordship may permit me to if your lordship may permit me to time petition before the tribunal, then it may be taken up next week, because what happened, my lord, in original application we have complied the order. In spite of that, a contempt application has been initiated, and
No,
again a
when
direction has
the
been
date
issued.
is fixed, if we take up we are taking up it on 16th.
16th, my lord. 16th.
Let me. It is give the full name, Mr. Counsel and counsel appearing for the petitioner submits that he has been entrusted by Mr. Sanjeev Swain to argue this matter on behalf of the petitioner, and he has already filed the wakalatnama. Let the registry place the wakalatnama and the name of the newly engaged counsel be reflected in the cause list in place of Sanjeev Swain, who is now in the panel of the state panel. Yes. Of the AG office question.
Item 6.
May I please? My lord, 5 decimal land has been acquired by the land acquisition officer in the year 2002, my lord. Thereafter, I have filed one objection, my lord, that was referred before the civil judge senior division Jagatsinghpur, my lord. Even if they have not issued any notice, my lord, I have appeared and filed one application for analogous of hearing on dated 1/9/21, my lord, but they have not reflected, and my land acquisition application has been dismissed, my lord. Thereafter, before filing of the application, my lord, I have approached before your lordship, my lord, but as per instruction of the learned civil judge, the matter was dismissed, my lord.
Now
That is
you
why,
are challenging the order dated 8/8/24.
my lord,
That is at page
Annexure
number
5, my
41. You please come to that order.
my lord. My lord, the petitioner in his petition for condonation of delay has not stated any sufficient cause or any cause except that the petitioner has no knowledge regarding the progress of the case.
Upon code पढ़ुचंदी. Please come to the impugned order dated 8/8/24, which has been passed in CMA number 99 of 23.
My lord,
That is impugned in this writ petition.
lord,
So please read it out.
had the London Council for the petition.
Why don't you use it, madam? Please use it. Page number 41.
41. Had the learned counsel for the petitioner perused both the petition as filed by the petitioner as well as the case record. On perusal of the record, it is noticed that the reference under section 18 of LA Act along with the petition of the petitioner have been received by this court on 2/11/2004. This court, due to non-appearance of the petitioner, since long past the order dated 8/4/22. By confirming the award passed by the LA officer, and they returned the petition to the LA officer Jagatsinghpur subsequent to the order, the petitioner filed this petition under section 151 of CPC on 20/12/23, and another application for condonation of delay dated 10/4/24. In the petition for condonation of delay, the petitioner has not submitted any cause of delay of 732 days as on filing of the petition dated 20/12/23. After passing of order of this court on 8/4/22, the petitioner in his petition for condonation of delay has not stated any sufficient cause or any cause except that petitioner has no knowledge regarding the progress of the case. All other grounds in the petition for condonation of delay is no way related to the sufficient cause for condonation of delay except the plea that there is no deliberate negligence nor any intentional laches on the part of the petitioner for his non-appearance on the date fixed, my lord. So lordship, see Annexure 3, my lord. Annexure 3 and Annexure 4, my lord, delay application. My lord, delay application I have stated in para 4, my lord. In para 4, my lord, that it is humbly submitted that an application for analogous hearing of the petitioner's case, page 37, my lord.
Page, no, page
37 of
annexure 3 कहले परा
Annexure 3, my lord.
para 5
Annexure 3 paragraph 5.
Paragraph 5, my lord. I have stated that it is further humbly submitted that an application for analogous of hearing of the petitioner's case in Miss Case number 351 2004 was filed for analogous hearing of along with hearing of LM Miss Case so and so, and from the same note, and as all of the LM Miss Case out of one Miss Case, and from the same notification, the character kisam of the said land also is same. And in the interest of justice to prevent abuse of the process of the court, in order to save the valuable times of the court, to prevent inconvenience to the parties, and to avoid extra expenses for effective adjudication for the ends of justice, the said petition is pending since 1/9/21, and no order has been passed in the said petition, my lord. So, Lordship may see Annexure 1 series, my lord. Annexure 1 series, your lordship may see they have issued notice on dated 29/8/2005, my lord, page 16, my lord. Thereafter, office comply the order 24/3/2006 to since 27/10/2008.
No, you are the petitioner. You are the petitioner.
My lord.
How do you say that you are not aware?
My lord, I was not aware because they have not issued any notice under section 20 as required.
ଆପଣ ନିଜେ ପରା କେସ୍ ଟେ ଫାଇଲ କଲେ।
ନାଇଁ ଏଇଟା ତ ସାର୍ 18 ରେ ଆଗ ଆସିବ ରେଫର ହେଲା ପରେ ସେମାନେ ନୋଟିସ ପଠେଇବେ।
ଠିକ ଅଛି ଆପଣ ଯେତେବେଳେ ଆପଣ କଣ ଜାଣି ନାହାନ୍ତି ଆପଣ କେସ୍ ରେଫର ହେଲା ବୋଲି
ରେଫର ହେଲା ତାପରେ ସେମାନେ ନୋଟିସ ଗୋଟେ ପଠେଇବେ କାରଣ ତାଙ୍କର ସବୁ କମ୍ପ୍ଲାଇନ୍ ନ କଲା ଯାକେ ସେ କରିବେନି କିନ୍ତୁ ସିଏ ଯେ ପର୍ଯ୍ୟନ୍ତ ନୋଟିସ ନ ଦେଇଥିଲେ ବି ଗୋଟେ 1/9/21 ରେ ଗୋଟେ ପିଟିସନ ଫାଇଲ କଲେ କିନ୍ତୁ that petition is not reflected by
तो 22 ରେ ଯେତେବେଳେ ଅର୍ଡର ହେଲା ତାପରେ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କଲେ ନାହିଁ
ଫାଇଲ କଲେ
କେବେ 2 ବର୍ଷ ପରେ
ନାଇଁ ସେଟା ମୁଁ ଜାଣି ନଥିଲା ମୁଁ
ସେ ଜାଣି ନଥିଲେ କହିଲେ କେମିତି ହବ you have filed a petition in 21
sir that is why I have stated another application is there that matter may be taken together, my lord.
No, when you filed a petition in 2021 that petition you pursued or not?
My lord, I have pursued.
What happened then? How can an order be passed in 2022?
Lord, they have not taken into consideration my application.
So what made you not to challenge the order of 2022 immediately? Why did you wait for it? Again, you are saying that I am not aware.
That is my not my knowledge, my lord.
How can you say this?
My lord, because and I have filed by your lordship may see
2004 ମସିହାରୁ 2022 ପର୍ଯ୍ୟନ୍ତ ଆପଣ ଟୋଟାଲ କିଛି ମାନେ ନେଲେନି ତାପରେ 2022 ରେ ସେ ମ୍ୟାଟର ଟାକୁ ଟେକ୍ ଅପ୍ କଲେ 8/4/2022 ରେ ଏବଂ the order was passed that there is no reason to defer from the amount of compensation already awarded and no scope to enhance or reduce the same. That is the order dated 8/4/2022.
My lord, they have not given any notice, my lord, and they have not disposed my application. And your lordship may see one judgment of this honorable court, my lord, because I have a land loser and my application is pending since 2002, my lord. They have not issued any notice, and even if I have appeared, and they have not stated my application, not taken into consideration of my application, my lord. And this, your lordship, I have nowhere. That is why I have filed one application.
So every time you are saying that you are aware of the position of the case and you have been pursuing your case, but in a particular period when the order was passed, you did not.
My lord, on 1/9/21, I have filed application, and because of that application's disposal, I am waiting, my lord.
How long? You have filed the petition and you will pursue the petition or you will... Now you are saying that I am not aware of.
They have not passed any order. Your lordship see another matter. Your lordship see they have stated and they have taken into consideration, but they have not passed any order, and thereafter passed order confirming the LA application, my lord. I have pursued my lord after 1991, my lord. 21, my lord. But they have not stated anything about my application, my lord. They have not taken into consideration. They have not stated that I have filed one application, my lord. And my recall application, my lord, they have not issued any notice. And
so what is the source? How could you know about this order then when you filed this petition?
My lord, because of pending of that application, when no order has been passed, my lord, I have approached before your lordship, my lord. That
No, 2022 order was passed and you filed a petition,
my lord,
to recall. When did you come to know?
My lord, that is why I have filed one application before.
When did you come to know about that? And how could you know?
Your lordship see order.
That is Annexure 3, CMA number 99 of 23 on date is given as 4/12/23.
My lord, your lordship see Annexure 2, page 30, my lord. Because I have approached before your lordship to for disposal of that application, and on that they have stated as per your lordship's direction, your lordship may see the matter is taken up through hybrid arrangement in view of the report of the civil judge senior division Jagatsinghpur that land acquisition miscase number so and so has already been disposed of on 7/2/23, my lord.
What was your prayer in that petition? In the 33528 of 23.
My lord, your lordship may see.
Have you got a copy of that petition with you?
I have that.
Yes, refer ହେଇଗଲା ପରେ is it the provision that even petitioner କୁ ମଧ୍ୟ notice ହବ?
My lord, as per section 20,
କୋଉ provision ରେ?
20, sir.
ଦେଖି
20 ରେ ଅଛି। LA Act.
Land acquisition act. କୋଉ provision କୁହନ୍ତୁ, let us see. ତାଙ୍କୁ କୁହନ୍ତୁ ବାହାର କରିଦେବେ।
ଏଇଟା ଅଛି। Section 20, ଏଇଟା ଯୋଉ LA ର ଏଇଟା land acquisition ନା ଏଇଟା ନୁହଁ ପୁରୁଣା
84.
ପୁରୁଣା 84 ଟା। Section 20, sir.
Land Acquisition Act 1894.
My lord.
It was in section 20.
20, my lord.
20.
20. Service of notice. The court shall thereupon cause a notice.
Wait, madam.
Friends, 20. Yes. Collector statement to report. Service of notice.
Applicant को भी अच्छी, courier applicant अच्छी, all the person interested in the objection तांको भी अच्छी. So ଏଟା ଯଦି ଆପଣ କହୁଛନ୍ତି ଯେ ଆପଣଙ୍କୁ ମଧ୍ୟ notice ହେବା ଦରକାର, even if you are the petitioner, then the order indicates that notice was issued also.
My lord, your lordship is the
27/10/2008 ଦେଖନ୍ତୁ, ସେଠି ମଧ୍ୟ ଲେଖା ହେଇଛି issue fresh notice ଅଛି। ତାପରେ
SR କୋଉଠି ରିଟର୍ନ ହେଇନି,
ଟିକେ
ଗୋଟେ ବି ନୋଟିସ ଆସିନି ବାବା।
ଟିକେ ରୁହନ୍ତୁ, awaiting SR, awaiting SR.
ଲାଷ୍ଟ 27/10/14 ଦେଖନ୍ତୁ sir।
ସବୁବେଳେ ତ awaiting sir, even if ତା ପୂର୍ବ
No,
date ଗୁଡାକରେ ମଧ୍ୟ
previous order not complied with.
28/8/2021, 23/11/2021, so on so.
The previous order not complied.
Neither the petitioner nor his counsel is present today. No step has been taken. एवढा ଲେଖା ହେଇଥାନ୍ତା ଯୋଉଠି notice ନା sufficient ହେଇଥାନ୍ତା, ଏମିତି କେମିତି ଲେଖିଦେଲେ?
It is a dealing assistant को explanation भी call for रही थी।
Page 27.
That's 20.
Immediate against the पूर्व
अच्छा।
जो order हुआ, include order तारो पूर्व।
पूर्वटा इटा।
Page 27. Last order मतलब सब देखुची awaiting SR. तापर parties take no step today.
ये हटा ट्रांसफर वाला पर ऑर्डर पास कर दे। Yes, record of transport to civil senior division. I pass order. Opportunity देखो। All right.
Who are the opposite parties in this case?
That LA officer and
You are appearing, Mr. Naik, for whom?
Since I am appearing for
All the opposite parties.
my lord, all the opposite parties.
So, in main ground is that the notice has not been served and he was not aware about it. That is how the delay occurred.
My lords.
So, you filed, if you want to file your counter, you can file it. Or if you say that
No, let it be, my lord.
Let
All
it be disposed.
the writ petition has been filed by the petitioner, Devi Prasad Das, which is prayer to set aside the order dated 8/8/2024, passed by 8/8/24, passed by the London Civil Judge Senior Division, Jagatsinghpur, in CMA number 99 of 2023, in which the petition filed by the petitioner to under section 151 of CRPC to recall the order dated
151 CPC.
151 CPC to recall the order dated 8/4/2022, along with the petition to condone the delay, has been rejected. It appears that the petition under section 18 of the LA Act was received from LAO Civil Land Acquisition Officer on 2/11/2004 in the Court of London Civil Judge Senior Division, Jagatsinghpur, and accordingly, LMS case number 351 of 2004 was registered. Thereafter, the matter was placed on different dates for office note, and then notice was issued, and it was adjourned from time to time, awaiting service return. While the matter stood thus, on 8/4/2022, the London Senior Civil Judge passed the order dated passed the order that neither the petitioner nor his counsel was present and no step was taken on their behalf. And it was further held that there was no reason to differ from the matter from the amount of compensation already awarded, and there is also no scope to further enhance or reduce the amount of compensation And accordingly, the order was confirmed, and the petition was returned. The petition was returned to the land acquisition officer, Jagatsimpi. The petitioner filed an application under section 151 CPC, which was registered as CMA number 99 of 2023 in the said LMS case number 351 of 2004, with a prayer to recall the order dated 8/4/2022. Inter alia, on the ground that the petitioner at no point of time was served with any notice for his appearance, either through process server of the court or by registered court. And in absence of the petitioner, the confirmation of the order of the land acquisition officer has caused serious prejudice and substantial loss to the petitioner, who was the landlord. And it was further stated that there was no deliberate negligence nor any intentional laches on the part of the petitioner for his non-appearance on the date fixed. And therefore, it was prayed for giving an opportunity of hearing to the petitioner by recalling the order dated 8/4/2022. The application under section 151 CPC was also supported with an application for condonation of delay. The learned counsel for the petitioner drew the attention of this court to section 20 of the Land Acquisition Act 1894, which deals with service of notice. And it states inter alia that the after the reference is made under section 18 of the said act, the court has to cause a notice specifying the date on which the court will proceed to determine the objection and will direct the appearance of the parties on that day. And such notice has to be served inter alia on the applicant and all the persons interested to the objection. The order sheet which has been relied upon by the Land Counsel for the petitioner has been annexed to this writ petition as Annexure 1 series, which would make it clear that at no point of time the notice on the LMS case number 351 of 2004 was served on the petitioner. Therefore, the observation that has been made by the learned senior civil judge in the order dated 8/4/2022 is that the petitioner, neither the petitioner nor his counsel is present is totally misconceived. Such uh, uh, recordings would have been made if the notice would have been duly served on the petitioner in terms of Section 20 of the LA Act 1894. After going through the application filed under Section 151 CPC, to also the application for condonation of delay, we are of the view that the observation made by the Lenin Civil Judge Senior Division Jagatsinghpur that there was laches on the part of the petitioner and no sufficient cause for condonation of delay has been shown is not acceptable. The Land Council for the state has also no serious objection to the submission made by the Land Council for the petitioner. After going through the averments taken in the petition, so also going through the copy of the petition filed under 151 CPC, so also the delay condonation application, we are of the view that the impugned order dated 8/8/2024 is not sustainable in the eye of law, and therefore the same is set aside, and consequently the order dated 8/4/2022 passed by the Lenin Senior Civil Judge in LA number 351 of 2004 stands recalled. The petitioner shall appear before the concerned court, that is the Lenin Swanto. Tell us a date, then you will appear on that day. Any date in the month of January. You appear on second week of January, that is on 13th is the Monday. So January 13 तारीख appear करो, है ना? 13th of January 2024. Whereafter the
25.
25. 25 is a Saturday. We do not know whether that court would be functioning on that day or not.
Any of the Saturday, my lord.
No, you appear once and thereafter you take
You appear once. Just
take instruction thereafter.
make fast appearance on front. Thereafter, the court shall proceed in accordance with law and try to dispose of the that case number LA miss case number 351 of 2004 as expeditiously as possible, preferably within a month of within a period of 3 months. It is made clear that we have not expressed any opinion on the merits. Yes.
Item 7.
May I please, Lordship? Lordship, on behalf of Siddharth Pathak Das, I pray for an adjournment.
Is there any interim order passed?
No, my lord, he is now in standing counsel so that he want to engage another advocate so that
Okay, mention is made on behalf of Mr. Siddharth Pathak Das for adjournment. Please this matter. January.
oblige.
Item 8.
Notice item 8 is a covered matter minutes covered by your lordship's order. I have annexed it in annexure number 2, page 26.
No, any change is to be
Yes, I have amendment.
for the agenda.
Item 9.
So, annexure 4 series.
My item 9. My representation is pending. Annexure 4, my lord.
Reflected.
Before the opposite at number 2.
Opposite party number 2. Representation is annexure
4.
4. Which one election? The annexure 4. Hello, annexure 4. That is to be displayed. Yes.
Item 10.
The second round of litigation, my lord. On the earlier occasion, the petitioner had approached this honorable court challenging that although his entire land, agricultural land as well as hospital land was acquired and compensation was paid to him, but
You are challenging the order dated 20 to 24.
My lord.
Passed in that page number 29 is that order.
My lord.
Okay, please come to that order. Back with them, page number 29.
The
Please place the third paragraph from third paragraph.
The petitioner in the petition has preferred
Is a mic that is
availing the benefits under the R&R policy. R&R policy 2006 against the land acquired for Dulang coal mining project of NTPC Limited. During the course of hearing, the petitioner submitted that his landed property of Mauja, Kapuri Kachar has been acquired under the Land Acquisition Act 1894 for Dulang coal mining project of NTPC Limited. He alleged that he has been awarded with the compensation due to acquisition of his land, but he has not been considered by the Land Acquisition Authority for providing the benefits under the Resettlement and Rehabilitation Policy 2006. The senior manager NTPC Limited Dulang stated that the petitioner is not coming under the displaced family on the ground that the petitioner is only a shareholder of acquired landed property recorded under Hal Khata number 26 of village Kapuri Kachar, but he is not a resident of the said acquired village. His name is also not enlisted in the list of entitlement matrix as displaced family. Hence, he is not eligible for Rehabilitation and Resettlement Policy 2006. The report of Tahsildar Hemgir also reveals that the petitioner is not a resident of the acquired village, Kapuri Kachar. As per the entitlement matrix duly approved by the collector Sundargarh on 29/8/2019, neither the name of the writ petitioner is enlisted as a displaced person, not as an affected person of the project. After hearing both sides and going through the documents on record, it is ascertained that the petitioner is not a resident of the acquired village Kapuri Kachar. As per the Rule 2D of the Orissa Resettlement and Rehabilitation Policy 2006, displaced family means a family ordinarily residing in the project area prior to the date of publication of notification under the provisions of the relevant act, and on account of acquisition of his homestead land is displaced from such area or required to be displaced. As such, the writ petitioner is not eligible for availing benefits under Rehabilitation and Resettlement Policy 2006. With the above observation, the prayer of the petitioner is rejected. Lordship, I have previously filed the writ application stating that there is no such provision in the R&R Policy 2006 that after acquisition of the land, entire homestead as well as agricultural land, a person has become landless and homesteadless. And there is no such provision.
2006, Radio, not 2003.
So the petitioner should be.
Have you got that 2006
My lord.
policy with you?
Policy is there.
He has referred to section 2D.
My lord. Section 2D, my lord.
2D is the reason.
Rule 2D of the Orissa R&R police.
2D of 2D টা এটা ভুল লিখ দিয়েছেন ওড়িশা পলিসি 2 নাই ঠিক তো সেটা ওটা কোন দিন লেখা কম্পারিজন তো So please read that definition. Displaced family. Of displaced family. Yeah. 2D.
Displaced family means a family originally residing in the project area prior to the date of publication of notification under the provisions of the relevant act, and on account of acquisition of his or homestead land, is displaced from such area or required to be displaced.
তো ଆପଣଙ୍କର ମନେକର 5ଟା ଜାଗାରେ ଜାଗା ଅଛି ଖଣ୍ଡେ ଖଣ୍ଡେ ଏଠି ଦି ଗୁଣ୍ଠୁ ସେଠି 2 ଗୁଣ୍ଠୁ ଏମିତି ରହିଛି ହେଲା ଆପଣ ଆଉ ଗୋଟେ ଜାଗାରେ ରହୁଛନ୍ତି ତ ଯୋଉ ଜାଗାରେ ଆପଣ ରହୁନାହାନ୍ତି ସେ ଜାଗାର ଜମିଟା ନେଇଗଲା ମାନେ ଆପଣ ଏଇ ଡେଫିନେସନ ଭିତରେ ଆସିଯିବେ କି ଯୋଉ ଜାଗାରେ ଆପଣ ରହୁନାହାନ୍ତି ଅର୍ଡିନାରୀ ଖଣ୍ଡେ ଜମି କିଣି ପକେଇ ଦେଇଛନ୍ତି.
That is my ancestral property. The land has been recorded in the name of my grandfather. Enter all the family members are residing therein, and that definition has also been clarified under Annexure 5, my lord. You will also kindly see page 23, Annexure 5. Not only in that place, but in the nearby area.
No. ଆପଣଙ୍କର ସେ ଜମି acquire ହେଲେ ଆପଣଙ୍କୁ you are entitled to compensation. That's a different matter. But for declaring you as a displaced family, because you are entitled to something more once you become a displaced family. For that, it requires that you should be actually ordinarily staying in that area.
In that area or nearby area. Nearby area means
project area କହୁଛନ୍ତି ଆପଣ
nearby project area. Annexure 5 your lordship may kindly see.
Ordinarily residing in the project area on the date of publication of notification.
My lord.
So that is one of the and another thing is there that on account of acquisition of his or her homestead land is displaced from such area or required to be displaced. So ଏଗୁଡାକ criteria ଆପଣ କେମିତି ଏଇ କେସରେ କାରଣ whatever report has come, it has come that you are not staying in that area. You have only that land, and for that land, obviously you are entitled to get compensation.
But I was staying in the nearby project area, and that has also been clarified at your lordship may kindly see page 23, Annexure 5.
23.
Yes, that is the notification issued by the Revenue and Disaster Management Department.
Yes.
That your lordship may kindly see
that is
clarification on displaced affected families with reference to Odisha R&R policy 2006. Here, it has been clarified. Last paragraph.
Yes.
Government, after careful consideration, have been pleased to clarify that a persons or families who were originally not residing in or near the project area are not eligible for and shall not be enumerated as displaced affected families for the purpose of resettlement and rehabilitation benefits. Persons or families who are normally residing in or near the project areas for a period of at least 3 years prior to the date of section 4(1) notification under Land Acquisition Act above may be considered as ordinarily residing therein for the purpose of so I was staying nearby the project area. That was my case.
First of all, ଆପଣଙ୍କର nearby project area ରେ ଆପଣ at least 3 ବର୍ଷ ପୂର୍ବରୁ 4(1) notification 3 ବର୍ଷ ପୂର୍ବରୁ ରହୁଥିଲେ ତାହେଲେ ଆପଣ ମଧ୍ୟ ହେଇପାରିବେ.
Yes.
ତେଣୁ ଏଇ ଆପଣଙ୍କର କଣ averments କଣ?
Averments your lordship may kindly see. I have stated and earlier
show us those paragraphs. Let us see your paragraph that how you are claiming that even though the displaced family is otherwise, but in view of that subsequent
Paragraph 8, my lord,
paragraph 8, let us see.
that the aforesaid representation letter 4 for 2022 was forwarded to the AGM R&R Project NTPC Limited, opposite partner 4 for necessary consideration, but the opposite partner 4 in his turn rejected the request of the petitioner on the plea that the petitioner was residing in village Kaporikachar before the notification is issued, and as such he was not eligible for R&R benefit. And this rejection order I had challenged before this honorable court, my lord, earlier.
What is the positive assertion, Lord and Counsel? We are asking you that if you say that in view of the circular which has been issued by the government in Revenue and Disaster Management Department on 2010, you are entitled to get the
Yes.
compensation as a displaced family.
Yes.
Is it not required that there should be a positive averments in your writ petition that you are staying there, that was near the project area, you are staying there at least 3 years prior to the 4-1 notification? All these averments are necessary or not? Because as such, displaced family ର definition ଭିତରେ ଆପଣ ଆସୁନାହାନ୍ତି, ଆପଣ invoke କରିବାକୁ ଚାହୁଁଛନ୍ତି ଯେ ଯେହେତୁ subsequently clarify କଲେ government in this 2010
Yes.
ଯେ ଯଦି ସେମାନେ 3 ବର୍ଷ ଭିତରେ ରହୁଥିବେ 4-1 notification ରେ ତାହେଲେ ମଧ୍ୟ ସେମାନଙ୍କୁ displaced family ରେ ଧରାଯିବ। ତେଣୁ ଏଥିପାଇଁ ଆପଣଙ୍କର ସ୍ପେସିଫିକ ଆଭରମେଣ୍ଟ ରହିବା ଦରକାର କି ନାହିଁ ଯେ ରିଟ୍ ପିଟିସନ ରେ?
No, what is the manner of your, how you are living there? Where is the averment?
କିଛି ନାହିଁ।
That you are normally living for more than 3 years during that period. Where is that?
Because they have rejected
In the nearby area.
Yes, madam, they have rejected my case that I was not residing at the same village.
ଆପଣ କେମିତି ଆଣିବେ ପଢିବେ ତ କିଛି ହେବେ?
ତାକୁ ତ ଆପଣ reject ବୋଲି ତ challenge କଲେ.
Yes,
So what is your assertion? What my lord is saying, what is your assertion to that?
My submission is that I was
Not submission, assertion.
I was residing in the nearby area.
Simply if you
that
say
has not
will
been
not
taken
do,
into
no?
consideration by
ଏଠି ତ ଆମେ ଏଭିଡେନ୍ସ ଗ୍ରହଣ କରିବୁନି, ଡିସ୍ପ୍ୟୁଟେଡ ଥିଙ୍ଗ ଭିତରକୁ ପଶିବୁନି, ଆମେ ଦେଖିବୁ ଯେ ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡ ହିଁ କଣ, ଆପଣଙ୍କର ଆଭରମେଣ୍ଟ ହିଁ ନାହିଁ, ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡ ନାହିଁ ଯେ ମୁଁ ଏଇ ଆଭରମେଣ୍ଟ ନେଇଛି ସେଥିପାଇଁ ମୁଁ ଏଇ 2010 ର ଭିତରେ ଆସୁଛି, that is why I should be considered as a displaced person and compensation amount is to be paid.
Yes, madam. Paragraph 9 I have stated. Page 7.
Let us see.
That the petition humbly state
Just a minute. Paragraph 9.
Paragraph 9.
Yeah.
Being joint family property, all the shareholders have equal share in the same, and for which the opposite parties have equally distributed the awarded amount in favor of the eligible members of the joint family. Besides, all the members are
କୋଉ
also
ଖାତା ନମ୍ବର, କୋଉ ଗାଁ କାଇଁ
କିଛି ନାହିଁ
ଅଛି?
because I have
ଆପଣ ସେମିତି averment ନେଲେ କେମିତି ଖାତା ନମ୍ବର କୋଉଟା, ପ୍ଲଟ ନମ୍ବର କୋଉଟା, ଗାଁ କୋଉଟା?
annexed to one. I have
How you say that it is a nearby area for the project?
I have annexed the ROR mayor.
Where is that? But you will not take averment for that. How can from the ROR we can know?
I have annexed the
No,
ROR. Annexed to
all
one.
right, that is a document that you have to substantiate, but in support of your contentions, where is the contention for that?
My submission is that they have not taken into consideration my
এটা କୋଉ
grievance.
project area କୋଉଠି ହଉଛି ସେଟା କୋଉଠି mention କଲେ? Project area
Project area is village Khapuri Kachar.
କପୁରୀ
Khapuri Kachar. When all the shareholders they have given the award amount and they have been extended the benefit of R&R policy, I have been deprived of my lord. That is the discrimination they have committed, my lord. That is why I have come, my lord.
This writ petition has been filed by the petitioner Harishankar Shah with a prayer to set aside the order dated 20/2/2024 passed by the collector Sundargarh, bracket re, opposite party number 2, in this case number 48 of 2023. It appears that the petitioner earlier approached this court in WPC number 20907 of 2023, challenging the later dated 13/5/2022 passed by the AGM NTPC Limited in rejecting his prayer for the benefit of rehabilitation and resettlement under RR Policy 2006. This court by order dated 19/7/2023 directed the opposite party number 2 to consider the representation filed by the petitioner and to pass appropriate order in accordance with law within a stipulated period. The opposite party number 2, after receipt of the order passed by this court, has been pleased to hold that after taking into account the statement of senior manager NTPC Limited, Dulanga. So also the report of the Tahsildar Hemgiri and entitlement matrix duly approved by the collector Sundargarh on 29/8/2019 that the petitioner is not enlisted as a displaced person nor as an affected person of the project. The opposite party number 2, considering Rule 2D of the Orissa Resettlement and Rehabilitation Policy 2006, which defines a displaced family, and states that the family ordinarily residing in the project area prior to the date of publication of notification under the provisions of the relevant act and on account of acquisition of the homestead land is displaced from such area or required to be displaced, can only be brought within such definition, held that the petitioner is not eligible to avail the benefits under RR Policy 2006 and accordingly rejected the prayer of the petitioner. The learned counsel for the petitioner placed the averments taken in paragraph 9 of the writ petition and further the circular of the government in Revenue and Disaster Management Department, where it is stated that the persons or families who are normally residing in or near the project areas for a period of at least 3 years prior to the date of section 4(1) notification under the Land Acquisition Act may be considered as ordinarily residing therein for the purpose of RR benefits. According to the Land and Council for the petitioner, the petitioner comes within this clarification which has been made on dated 2010 by the government under Annexure 5. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite parties number 1, 2, 3, na? 1, 2, 3. Extra copies of the writ petition be served on the Land Council for the state. So far as opposite party number 4, ताकि panel council the NTPC रो ना ना notice दिवो for issuance of notice shall be filed within 1 week. Please this matter after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes.
Item 11.
Obliged.
Honorable Lord, to challenge the judgment dated 7/10/2024, page 49, passed by the presiding officer L&R Barampur, wherein he rejected the claim.
Challenge in Annexure 10.
Annexure 10.
Please come to that.
My lord.
So, page 50 indicates that, just read that first paragraph. Why are you not using that? Welcome. Land Council, please use that. Come to page number 50, the first paragraph itself.
My lord. Dispute relating to apportionment, award compensation,
Apportionment of the awarded compensation. Yes.
case number 74/15 has been referred under section 64 of the right of fair compensation and transparency in land acquisition, rehabilitation, and the Settlement Act 2013 by the Collector Command Yellow Ganjam Chhatrapur for settlement.
Now you come to the operative part of the order, particularly page number 58. Page number 10 of that internal page of the judgment and the running page is 58.
My lord.
The facts and circumstances.
The fact and circumstance of this case established that Padmanabh Panda and his wife, Dindamani, had purchased the acquired land out of their income. During lifetime of Dindamani Panda, she had sold some portion of her purchased land along with her husband Padmanabh Panda to Biptrajala Palingirai and others. That a part, the deceased Dindamani had executed Willnama Exhibit 2 in respect of the acquired land and other lands of her in favor of her husband Padmanabh Panda. As such, there is no reason to hold up the disbursement of the compensation amount only for the reason of pending civil suit. While Padmanabh Panda is alive, the petitioner Padmanabh Panda is not entitled to any portion of the award compensation.
So, how you are related to that Padmanabh Panda?
Son.
Acha.
And
so, how many children, Mr. That Padmanabh Panda has?
Padmanabh Panda has, my lord. 3, my lord, including the petitioner, 2 daughters and 2 sons.
Yes.
2 daughters. Up in our 6 and 7.
Okay. So, that averment, which the finding which has been given there, it indicates that your father and Dinamani, mother, they purchased the land.
Yes.
Right? And during the lifetime of Dinamani Panda, she sold some portion along with her husband to Bipin Charan Panigrahi. And then deceased Dinamani executed willnama in respect of the acquired land and other land in favor of her husband Padmanath Panda. So there is no reason to hold up the disbursement compensation, so and so. Padmanabh Panda is alive. So why you will get the compensation? Your father, if the
Is
land
alive.
stands, is alive, and you have got the sisters also.
I am the successor of my mother. My mother is now not alive. I am the one of the successor. And a partition suit is pending
No,
before
your
this.
mother has already executed willnama, Exhibit 2,
That
in
has not
respect
been
of the.
proved. The willnama, the exhibited 2 has not been proved.
Not been proved means it has not been probated.
Yes.
It has not been
No.
probated.
Yes, Mil, that is not been probated.
Okay, that is that in respect of the acquired land and other lands also, it has been done in favor of the husband. So your father is also alive, and why you will be will be given the entire thing.
My sole ground is this suit for partition is pending, was pending at the relevant time. And pendency of that civil suit, my
No, that was the self-acquired property of mother and father. And mother has already bequeathed. So why you will get?
son.
Under what provision? Mother has bequeathed it. It's a self-acquired property. Why you will get?
The mother is already died.
It is already bequeathed in favor of father. It is a self-acquired property.
Mother is died. The share of the mother.
Prior to that, it's a bequeath. And it's self-acquired property, not a property of ancestors.
Ancestral property, no.
Self-acquired
property.
Well, let's now come to page 9.
Yes.
The partition suit has been dismissed.
Oh, that is also dismissed.
Page 94, my lords, may kindly come to the relevant portion.
Page
94, my lords. Running page 94 of the page of the judgment is 34, para 7.1.
7.1. Wait. Yes. Please place it that paragraph, Mr.
It is. I'll place me.
Yes.
It is noteworthy to reflect here that the plaintiff has not adduced a single record of right suggesting
Who
that
has filed this suit?
the petitioner
Yes.
not adduced a single record of right suggesting therein that the right in respect of the suit settled property has devolved upon his father Padmanabh Panda from his predecessor in interest. There is no documentary proof to suggest the antecedent title in favor of the forefathers of Padmanabh Panda, so that the plaintiff can put forth his claim for partition of the suit scheduled properties. On the other hand, the plaintiff by his own admission has accepted the fact that the defendant number 1, being engaged in government service and having left the same, pursued agricultural business as his avocation with lucrative profit. Hence, the attending facts and circumstances leads to an irresistible conclusion that the suit scheduled property is the self-acquired property of Padmanabh Panda. Since the suit scheduled property is the individual acquisition of the defendant number 1, hence, the plaintiff cannot, as a matter of right, seek partition of the same, as the defendant number 1 can deal with the property as per his own choice. This, my lord, is assailed in a first appeal before the learned district judge. That is pending. So the operation of stay and whatever reliefs he is seeking may be sought before the learned district judge, my lords.
The matter is pending before
My
the
lords.
court.
So after it is set aside and it is done, you may get something. Otherwise, at this stage, when the order was passed, you are.
Money will be disbursed.
No, just come to that order. When this judgment was passed on 17/24. So the judgment which was pronounced by the
710.
No, 710.
910.
In that civil suit.
Civil suit 9.
9,
10,
just 2 days after. What is the result of that RFA? This writ petition has been filed by the petitioner Pramod Ranjan Panda, son of Padmanabh Panda. for passing the judgment and order dated 7/10/2024 of the presiding officer, land acquisition, rehabilitation and resettlement officer, Berhampur in LAR and R case number 9 of 2020 under Annexure 10, with a further prayer for a direction to the opposite party number 3 to award compensation share in favor of the petitioner. The impugned order indicates that the dispute arose to the apportionment of the awarded compensation in LA case number 74 of 2015, which has been referred to the court of LAR and R authority, Berhampur, and accordingly LAR and R case number 9 of 2020 was registered under section 64 likely 64 of right to fair compensation and transparency in land acquisition and rehabilitation and resettlement act 2013 by the collector cum LAO Ganjam Shatrapur for settlement. After assessing the evidence adduced the oral evidence, also the documentary evidence, the court was of the view that Padmana Panda, bracket to father of the petitioner, and his wife Dinamani, bracket mother of the petitioner, had purchased the acquired land out of their income, and during the lifetime of Dinamani Panda, she had sold a portion of her purchased land along with her husband Padmana Panda to one Biprocharan Panigrahi and others. And that apart, the deceased Dinamani executed Willama in respect of the acquired land and other lands of her in favor of her husband Padmana Panda. And therefore it was held that the disbursement of compensation amount only for the reason of pending of the civil suit is not acceptable, and moreover Padmana Panda is alive, and therefore the petitioner is not entitled to any portion of the awarded compensation, and thus the court directed that the awarded compensation be disbursed in favor of Padmana Panda for the land and structure existed over the acquired land to the extent of acre-sum 030 decimal, and the awarded compensation for the acquired land to the extent of acre-sum 019 in favor of Sivaram Panigrahi. As it appears, the very that Mr. Naik, you are placing that para 7.1 page 94.
Page 94.
94. Acha, as it appears, as it appears, the petitioner instituted civil suit number 209 of 2011 in the court of Senior Civil Judge Barampur Ganjam, seeking partition of the suit scheduled property comprising of movable and immovable properties of the Hindu undivided family available with Karta Padmanabh Panda and his wife Dinamani Panda through the process of the court. And after taking evidence from both the sides, both oral as well as documentary, the court was of the view that the plaintiff bracket petitioner has not adduced a single record of right suggesting therein that the right in respect of the suit scheduled property has devolved upon his father Padmanabh Panda from his predecessor in interest, and there is no documentary proof to suggest the antecedent title in favor of the forefathers of Padmanabh Panda, so that plaintiff can put forth his claim for partition of the suit scheduled properties. On the other hand, the petitioner bracket plaintiff bracket petitioner by his own admission had accepted the fact that the defendant number one, that is Padmanabh Panda, being a government, being engaged in government service and having left the same, pursued agricultural business as his avocation with lucrative profit, and therefore the attending facts and circumstances led to the irresistible conclusion that the suit scheduled property was the self-acquired property of Padmanabh Panda. And since the suit scheduled properties were the individual acquisition of Padmanabh Panda, the plaintiff cannot, as a matter of right, seek partition of the same, as Padmanabh Panda can deal with the property as per his own choice. And accordingly, the suit was dismissed. Stop. It appears that the petitioner has challenged the said order, judgment and order passed by the London Senior Civil Judge Barampur Ganjam before the London District Judge Ganjam Barampur in RFA number 134 of 2024.
132 lords.
34 লেখা है जी
134 of 2020.
page 99 को আসুন
page 111
ভুল লিখছেন কি এটা
sorry মেলর এটা ইয়ে নাম্বারটা আমার
page 134 of 2024 which is sub judice. Stop. After hearing the London Council for both the parties and the reason assigned by the opposite party number 3 in the impugned judgment and order dated 7/10/2024, we find no illegality or impropriety in the same. Therefore, this writ petition being devoid of merit stands dismissed. Yes.
Is a writ petition, what have we provided?
Yes, who is appearing here?
Item 12.
Item 12. चेंज चांज जहाँ कर दी हाँ पिटिशन ना चेंज हो आउ से रिप्रेजेंटेशन नंबर
Annexure 9.
ସେଥିରେ ବି annexure 9 ଥିଲା
Yes.
okay please forward
Item 13.
13, my lord, I may permit to withdraw and file a better application. My lord, I'm not happy with the petition at all.
Mr. Yashovan Das, Grand Senior Advocate, appearing for the petitioner, seeks permission to withdraw the petition to file a better one. Accordingly, the petition is disposed of, giving liberty to the petitioner to file another petition. Yes.
Item 14.
My lord, in this matter, petitioner is challenging illegal arbitrary direction of this opposite party by directing bank not to proceed of the sale which has been mortgaged with the bank from since 2003 and the bank's charges continue. My lord, in this matter, I am straightway coming to the mortgage document, that is EM confirmation letter, page 72, annexure 6.
No, you are challenging the order passed in the
By the page 12, annexure 1, by the civil supplies officer.
No, come to your prayer first. Let us.
Madam. Under the aforesaid
page number 9.
Page number 9. Under the aforesaid circumstances more fully narrated herein, above, the petitioner most humbly prays that this honorable court may graciously be pleased to duly say, calling upon the opposite party's focus as to why the certificate proceeding dated 2/12 pending in the collector cum certificate officer Suvarnapur initiated at the instance of the opposite party and its consequential letter 29/5/2024. By when this bank charge is continuing, they have proceeded with this certificate proceeding, and out of that, this order has been passed. And moreover, this I have annexed the judgment of this honorable court. It speaks clearly when the charge is continuing, corporation cannot override it and can attach to this thing. And this is also civil supply. Kindly. And it comes to the
annexure 1 questions.
Annexure 1.
You want this should be quashed, right?
Quashed, Arbitrarily directed us bank not to proceed for sale. Following due procedures of sale, it was mortgaged in 2003.
No, just read it out.
In inviting a reference to your e-action sale notice dated 15/5/2024.
Yes.
On the aforesaid subject, I am to inform you that the immovable properties, the khata number so and so, Mouja, plot number so and so, mentioned in the e-action sale note dated 15/5/2024 of Messrs. Rani Sati Paddy Processing Private Limited, Moujas, Suvarnapur are attached in the certificate case under OPDR Act by case number by the collector cum certificate officer Suvarnapur from dated As the aforementioned properties are attached in the certificate case, you are requested to withdraw your e-action sale notice as we are the first party over the properties for recovery of the misappropriated amount of from the defaulting custom miller during so and so, my lord. In view of the aforesaid facts, it is requested to withdraw the e-action sale notice published and dated 15/5/2024 immediately.
Yes.
Otherwise, you will be held responsible for the further legal consequences in this matter.
So, apart from the fact that he has kept this property under mortgage with the bank, it appears that he has already misappropriated an amount of huge amount from the defaulting custom miller. That was in the year 2009 and 10. So, when he availed loan from you?
2003.
2003.
Kindly come to the page 72, where he has confirmed the creation of equitable mortgage in favor of the bank for availing the loan. Agreement starts from earlier. Agreement of the loan starts from the page 13, but EM confirmation is completely showing that this property is mortgaged with the bank for availing the loan.
So, did you move with the certificate officer on that?
My lord?
After this letter was issued, having come to know that under the OPDR Act, this has already been attached,
My lord.
did you file the objection?
No, my lord, that
obviously, because the property has wrongly has already been attached by the certificate proceeding. And you being the bank, the property being your first charge,
my lord,
you should first immediately file an objection.
That I think so,
that is required.
But I have to,
because that is a altogether different authority where it has already been proceeded. So you file the objection. If they do not take it, the collector do not take it as certificate officer, then you have a appellate authority under section 60.
My lord, with due respect, my lord, this judgment which I have been attached, it is pertinent to this way, and there he is telling that corporation cannot go for attachment of this. My lord, kindly.
This subject matter of this one.
My lord, this I have
particular
annexed
property.
This particular property.
No, my lord, this is against also civil supply.
No, the fact, whether
Civil
the
supply
factual aspect are similar in nature.
Similar, my lord, in nature.
It was attached in the certificate proceeding.
No, my lord.
Then that is why it is already with the. You file objection.
My lord, may I pray, my lord? I will let me.
You opportunity, you file your objection.
My lord, kindly, may I pray for one date? Let me.
Next week, if you are good.
Let me take instruction that whether we have move or not.
All right.
May not supply me copy.
All right. Mr. Guru and counsel for the petitioner. 6 adjournment till next week.
Any day, man. Monday, Tuesday. As man.
This matter on 17th, Tuesday, 17th December 2020.
Please, Your Lordship.
Item 15.
Please, Your Lordship. Lordship, I am challenging the order passed by the Orissa Real Estate Appellate Tribunal on dated 18th of November 2024, rejecting my application for waiving of the payment of the prerequisite deposit in the appeal, Your Lordship. Your Lordship, I am a bank. I have preferred an appeal before the Orient, challenging the order passed by the adjudicating authority ORERA.
Please come to the impugned order.
Yes, Your Lordship.
Give those books. Real Estate Regulation and Development Act 2016. Yes. You see, in the cause list, there is a noting that whatever act you want to rely on, please give it to the courtmaster so that it will be avoid unnecessary delay. You are not for.
I beg your pardon, Your Lordship.
Just a minute.
45.3, Your Lordship. This is the
ସେଇ ଆକ୍ଟ ବାହାର କରିଲେ ତାଙ୍କୁ ବହିଟା ନେଇ ଆସିବ ସେ କେମିତି ଆକ୍ଟ
ସେଇଥିରେ ନଥିବ ଭାଇ ଆମର ସେଇଥିରେ ନଥିବ।
Well, I'll have it on my iPad.
Yes, first read the order, impugned order, then we'll go to that.
Lordship. This is an application filed by the appellant for waiving of the statutory deposit. It is contended that the interlocutory application that the appellant does not stand in the same footing as the promoter. As per section 43(5) of the Real Estate Regulation and Development Act 2016, and the appellant may be exempted from depositing the prescribed fee in the interest of justice. Section 43(5) of the Real Estate Regulation and Development Act 2016 clearly envisages and mandates for deposit of statutory amount in order to maintain the appeal. The aforesaid provision has already been affirmed and confirmed by the Honorable Apex Court in the case of New Tech Promoters and Developers Private Limited versus State of UP and others, reported in 2001 SEC Online SC 1044. It has also been reiterated by the Honorable Court of Punjab and Haryana, High Court of Punjab and Haryana at Chandigarh by judgment dated 16/10/2020 in CWP so-and-so and other connected matters have inter alia held that at para 15 of the judgment, typically where the appellate tribunal rejects the plea of the appellant for waiver of pre-deposit, then it grants one more opportunity to the appellant to make the pre-deposit within a reasonable time, failing which it will dismiss the appeal on the following date it has fixed for hearing the appeal. This is what has, this is the observation of the court before in the Punjab and Haryana High Court, Your Lordship. In view of the extent provision of the statute coupled with the decision of the Honorable Apex Court as well as decision of the Honorable Court of Punjab and Haryana, High Court of Punjab and Haryana, the depositing of statutory amount is condition precedent for entertaining the appeal. In absence of deposit of statutory amount, this tribunal is bereft of any power for exempting payment of statutory amount, for which this application for waiving of statutory amount is thoroughly misconceived, and accordingly the IA is dismissed.
Okay, now you come to the, let us see.
My lord, section 43, subclause 5. Your Lordship.
79.
Yes, 79.
May I read, Your Lordship? 43, subclause 5.
Hold on.
Subclause 5 states that any person aggrieved by any direction or decision or order made by the authority or by an adjudicating officer under this act may prefer an appeal before the appellate tribunal having jurisdiction over the matter, provided that where a promoter files an appeal with the appellate tribunal, it shall not be entertained without the promoter having first deposited with the appellate tribunal at least 30% of the penalty or such higher percentage as may be determined by the appellate tribunal, or the total amount to be paid to the allottee, including interest and compensation imposed on him, if any, or with both as the case may be, before the said appeal is heard. Now, Your Lordship, I am not the promoter, I am the bank. The matter starts here. My Lord, may kindly see annexure 2 at page 16, Your Lordship.
Just to come to the definition of promoter.
Yes, Your Lordship.
Section 2ZK.
Yes, sir. Promoter means a person who constructs or causes to be constructed an independent building or a building consisting of apartments or converts an existing building into a part thereof into apartments for the purpose of selling all or some of the apartments to other persons and includes his assignees. A person who develops land into a project, whether or not the person also constructs structures on any of the plots for the purpose of selling to other persons all or some of the plots in the said project, whether with or without structures thereon. Any development authority or any other public body in the respect of allottees of buildings or apartments, as the case may be, constructed by such authority or body on lands owned by them or placed at their disposal by the government. Plots owned by such authority or body or placed at their disposal by the government for the purpose of selling all or some of the apartments or plots. An apex state level cooperative housing finance society and a primary cooperative housing finance society which constructs apartments or buildings for its members or in respect of allottees of such apartment or building. Any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by any other name, or claims to be acting as the holder of the power of attorney from the owner of the land on which the building or apartment constructed or plot is developed for sale. Such other person who constructs any building or apartment for sale to the general public.
What is the decision of the Honorable Supreme Court?
My lords, in that decision of New Tech Promoters and Developers Private Limited versus the state of UP, Your Lordship, in that case, Your Lordship, the wires of this particular section 43(5) was challenged. The person who has challenged in that writ application before the Honorable Apex Court, he is a builder, Your Lordship. Admittedly, the name suggests he is a builder. He has challenged the wires of the section that why shall he pay that amount? And the Honorable Supreme Court in para 136 of the judgment at page 35, Your Lordship.
Wait. One.
Page 35, para number 136, Your Lordship.
To see that what was challenged there.
136, page 35 of the judgment, para 136, Your Lordship.
Yes.
No, it's,
You have got another copy with you.
my lord, I have it on my,
All right, please press that.
my lords,
136 says it is indeed the right of appeal.
yes. It is indeed a right of appeal which...
No, 137 you come to that.
Yes, Your Lordship. In our considerate view, the obligations cast upon the promoter of pre-deposit under section 43(5) of the Act being a class in itself, and the promoters who are in receipt of money which is being claimed by the home buyers allottees for refund or determined in the first place by the competent authority, if legislature in its wisdom intended to ensure the money once determined by the authority be saved if appeal is to be preferred at the instance of the promoter after due compliance of pre-deposit is envisaged under section 43(5) of the Act, in no circumstances can be said to be erroneous as prayed for or in violation of Article 14 or 19(1)(g) of the Constitution of India.
Okay, in this case, particular case, who is the promoter?
The promoter is the opposite party number 2, Your Lordship. Opposite party number 3, Your Lordship.
Party number 3.
Yes, Your Lordship. Orissa Homes and Commercials Private Limited.
Who is this opposite party number 2?
Opposite party number 2 was the petitioner before the adjudicating authority against whom I had preferred the appeal before the Orient. And, Your Lordship, I may pray.
What was the claim of the bank?
No, the bank claimed nothing.
No,
In the appeal.
In the appeal.
My lords, before the adjudicating authority, the opposite party number 2 claimed a compensation of rupees 20 lakhs against the opposite party number 2, who was the respondent number 1. I was the respondent number 2. But without having any prayer against me, I was only a proper party in that case, being a bank having secured its interest over the property.
No, why you prefer the appeal?
The adjudicating authority of Orera passed an order directing me and the opposite party number 2 jointly and severally to pay 2 lakhs as compensation, whereas there was no prayer against me. My lords, even if I am directed to...
Where is that order?
Your Lordship, I'll
which has been challenged in the appeal.
Your Lordship, I have attached that.
Which is that annexure?
It is... Your Lordship, it is at page number 38, running page 38.
38?
Yes, Your Lordship.
Against this order, appeal was filed?
Yes, Your Lordship.
So, where is that portion of the, you said that
my lord,
you are also fixed the, which page?
My lord, page 40, my lord...
jointly liable. Respondents who severally and
jointly 47,
directed to pay compensation of rupees. You are one of the respondents.
Yes, Your Lordship.
You were not a respondent. You were a respondent.
Yes,
yes.
Respond number?
Respond number 2.
2.
That petition is also attached, Your Lordship, at Annex 2, Your Lordship.
38 respond number is the SDFC.
But Annex 2 is that petition which the opposite party number 2 had filed.
All right. This writ petition has been filed by SDFC Bank Limited, challenging the order dated 18/11/2024 passed by the Land Variety Bhubaneswar in IA number 271 of 2024, which arises out of Variety Appeal number 114 of 2024, with a further direction to exempt the petitioner from making the statutory deposit as prescribed under section 43(5) of Real Estate Regulation and Development Act 2016, hereafter 2016 Act. It appears that The opposite party number 2, Dhiren Kumar Sahu. Preferred AOCC number 20 of 2023 before the adjudicating officer, Orissa Real Estate Regulatory Authority, Bhubaneswar, under Section 31, reduced Section 71 of the Real Estate 2016 Act, claiming compensation of rupees 20 lakhs from the respondents for mental harassment and damages, and rupees 8 lakh 2,713 towards house rent, which could have been accrued from 2012 till 2/2/2018, that is the date of delivery of possession, bracketed total 5 years and 2 months, along with interest for delayed delivery of possession of the flat in question. In the said complaint, the petitioner bank was respondent number 2. The London adjudicating officer by order dated 19/6/2024 has been pleased to hold that the respondents, that is so and so, and the petitioner bank are severally and jointly liable to pay compensation of rupees 2 lakhs to the complainant, bracketry opposite party number 2, within a period of 45 days, failing which the amount shall carry interest at the rate of 9.50% per annum till total realization. Inter alia with other directions. The petitioner bank challenged the aforesaid order passed by the London adjudicating officer by filing an appeal before the Real Estate Appellate Tribunal Bhubaneswar under Section 44 of 2016 Act, and the same was registered as OREAT Appeal number 114 of 2024. And a prayer was, an application was filed by the petitioner bank under Section 43(5) of 2016 Act to exempt the petitioner from depositing the prescribed fee in the interest of justice, which has been torn down by the impugned order dated 18/11/2024, taking into account the ratio laid down by the Honorable Supreme Court in the case of New Tech Promoters and Developers Private Limited versus State of UP and others reported in 2021 SCC Online 1044 and a decision of the Punjab and Haryana High Court. and it was held that the depositing of statutory amount is a condition precedent for entertaining the appeal. And in absence of the deposit of statutory appeal, the tribunal is bereft of any power of exempting payment of statutory amount and accordingly dismissed the interim application. The Grand Counsel for the petitioner submitted that the Honorable Supreme Court in the case of New Tech Promoters and Developers Private Limited (Supra) has been pleased to hold that the obligation is cast upon the promoter of pre-deposit under Section 43(5) of the Act, being a class in itself, and the promoters who are in receipt of the money which is being claimed by the home buyers allottees for refund and determined in the first place by the competent authority, if legislature in its wisdom intended to ensure that money once determined by the authority be saved in if appeal is to be preferred at the instance of the promoter after due compliance of pre-deposit as envisaged under Section 43(5) of the Act, in no circumstance can be said to be onerous as prayed for or in violation of Articles 14 and 19(1)(g) of the Constitution of India. Land Counsel for the petitioner referred to Section 43 of the 2016 Act, 43(5), which reads as follows. Quote the entire thing, 43(5). The Land Council further placed the definition of promoter, which is there in Section 2ZK. Quote it from this one. So it is submitted by the Land Council for the petitioner that within the definition as provided under Section 2ZK, the petitioner bank cannot come within the definition of promoter. Therefore, the proviso is not applicable. The proviso as per the Section 43(5) is not applicable to the petitioner, and therefore the impugned order passed by the Land and Real Estate Appellate Tribunal Bhubaneswar is not sustainable in the eye of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Who are to accept notice, Mr. Naik?
I think
This
panel lawyer should be.
Biren Kumar Sahu to notice jibo private Odisha homes commercial भी jibo. आपण ये जो ओडिशा स्टेट एपिलेट ट्राइब्यूनल याकू कहीं पक्ष कोर्ट को कहीं पक्ष करचंदी आपण no notice be issued to opposite party number 1. Requisites for issuance of notice to opposite parties number 2 and 3 be filed within 1 week. Matter be placed after 4 weeks. Counter affidavit, if any, be filed in the meantime.
Item 16.
Please, in this matter, Miller, the petitioner is challenging Annexure 4, that is the order passed by the district collector cum district magistrate against one dead person, Shambhunath Jena. The order is not. I have neat legible copy, 18, page 18. Page 18 is the neat legible copy I have given.
Please. Yes, so what is it?
It was mentioned that pursuant to the provisions of Section 14 of the SARFAESI Act 2002,
And
you are challenging section 14 order.
Yes, your lordship.
Go to the appropriate forum.
On the ground that kindly have a
Whatever
glance
may
to
be ground, you can take that ground before the
page 16, your lordship.
yes, appropriate forum. Yes, next.
Against a dead person.
Take that ground there. Yes, next.
Item 17.
Lord, in this case, I have filed an IA 2327 of 2024.
Copy of the IA make it.
You have filed an application for bail of appellant number 3.
3, yes, my lord.
So why have you not given a copy of the to the Land and Council for the state? Give it. We'll take up next week. Okay. On your this is on merit or on interim application on any health ground?
No, my lord.
What is this application?
Last occasion, your lordship directed for interim bail for 1 month. And he has availed that order and has not violated any terms and conditions.
Oh, so it is subsequently.
Another application.
Yes.
Let give him a copy.
My lord, I will serve.
Mr. Mahapatra, you are appearing for whom?
Yes.
Have you received a copy of the? Please give it.
My lord, I will.
IN number 327 of 2024. This is an application for bail. Let a copy of the interim application be served on the Land Council for the state as well as Land Council for the informant. The Land Council for the appellant submits that the petitioner was granted interim bail for a period of 1 month.
1 month, yes.
By the order dated
31/7/2024.
31/7/2024 in IN number so and so. And after availing the same, we surrender at right time.
Surrender at
right time. Let the Land and Council for the state obtain instruction to the concerned IAC about the conduct of the petitioner while on interim bail. Yes, put up this matter. After Xmas holidays. Yes, next.
Item 18.
When the petition book for bail, my lord, the appellant has been convicted under some 3.
How many times your bail application was earlier rejected?
My lord, at the time of filing appeal, my lord, he has filed the bail application which has been rejected, my lord.
Which was rejected?
My lord. But thereafter, in the year 2013, my lord, then thereafter he has not filed any bail application.
Okay, so since when you are in custody?
My lord, on 9/10, my lord, that is my lord, 4/9/2013, my lord.
4/9/2013.
13, my lord.
Ramesh Panda.
Ramesh Pandey, my lord.
Pandey,
my lord. Wrong, that is mentioned Ramesh Panda, my lord.
Panda Lakhaiji. You are the sole appellant in this criminal appeal.
My lord, sole appellant, my lord.
So
other connected matter, my lord, I am the only this appellant, my lord.
It's all right. Your date is mentioned as 5/9 forwarded to court. You are never released on bail during trial.
No, my lord.
Let us see that. Order sheet order sheet. Okay. Accused persons produced in custody, produced in custody. Produced in custody. Okay. So, your bail application was rejected on what date? It appeal on you rejected.
18/12/2018.
18/12. Yes, your so it appears that the petitioner has been identified in the TI parade. Okay. Yes, under section
302.
302.
My lord, /34, my lord.
Okay. So, what you have done? What is the allegation against you?
That the appellant, along with 3 other co-accused persons, my lord,
come to paragraph
this is my lord.
Para 2 question to page number 2 of the impugned judgment.
My lord.
Paragraph 2.
The prosecution case in brief is that on 30th 8 2013, the informant
Mic adjust karantu.
Yes. My lord, the informant Ankur Harijan, along with the other co-villagers, namely
So and so chhad diyantu. Tapare had been to Khariar.
had been to Khariar for purchasing of bullocks. After purchasing bullocks, they proceeded towards their village, Janiguda, situated under Nabarangpur district. On that day, in the evening, they took a halt near the village Paraspada at about 7 p.m. They received a phone call from about the death of the father of the Pitambar Bisoi, who is the deceased male. After receiving phone call at about 8:30,
Deceased hoji Pitambar Bisoi.
Pitambar Bisoi male.
Okay.
After receiving phone call at about 8:30 p.m., Pitambar Bisoi, Padam Bisoi and Butti Bisoi left for their village. They asked the informant and other associates to come on the next day early morning on 31st 8 2013 in the early morning. The informant and two of their associates proceeded towards their village. On the way near Kodaboda, Dongiriguda road, they found Pitambara Bisoi lying dead with a pool of blood, and the other co-associates, namely Padam Bisoi and Butti Bisoi, sustaining bleeding injuries on their heads. Being asked about the incident, they explained that in the previous night at about 10 p.m., 4 unknown persons came and arrested them on the way and assaulted them by means of lathis and stones.
So eyewitnesses are there.
Eyewitness,
and you are unknown to those persons.
My lord, eyewitness, that is 10 and 11.
PW 10 and 11.
11, my lord.
They identified you in the TI period.
TI period, my lord, only one person, one accused, that is PW 9 identified me, but not PW 10.
That 10 and 11 are the injured persons?
9 and 10.
9 and 10.
9 and 10.
So 9 and 10 are the injured persons.
My lord.
And out of them, both identified or one?
Only one, my lord. 9 have not been identified, but 10 have identified the concerned appellant.
9 has failed to identify any of the persons.
My lord, that is the present appellant, other along with other appellant, other co-accused person, my lord. So far the PW 10 is concerned.
Please stay. Wait for a moment.
Page 117.
No, kahar evidence portion. Now 9.
9 para.
PW 9. PW 9 now is para Padam Bisoi.
My lord.
Well, I know the accused fella.
Page 18, my lord. Page 8, my lord. Of the judgment, my lord.
Judgment,
statement. Page 117. Page 117.
We are there.
Four line, four paragraph ta poduchandi pa.
Paragraph 5.
Tell that.
The witness identified one like in the dog. That is in the court. Na TI period. Doctor to chinilla. He is not saying about TI period.
Identified the petitioner now ji Ramesh Panda.
My lord.
Ramesh Panda को किए चिन्हला?
My PW 9, my lord. That is my lord. PW 17, my lord. JMS is the TI period, my lord.
We are fast. Court identification है ही नहीं. तापर TI period को जीवा. Court identification है ही ना नहीं.
Court Ramesh को identify है ही की. Go witness करते.
आपनकर FIR होची unknown ना?
Unknown.
तो FIR unknown ता माने एमाने कई जानी नाहंती तांकर identity. सेही पे आपन TI period कर ले.
TI period है.
TI period रे identify है ही. That's all right. Now you are coming to that whether court रे identify है ही ना नहीं.
Here they say that Peter 10 is saying that I know the accused persons.
Yes, my lord. I know the deceased about the 3 years back of the occurrence.
Mr. Nayak, one thing you should remember that the identification in the TI period is not a substantive piece of evidence. So it has to be, this man is again to be identified in the court also, right? So if in the court, the witness fails to identify merely because his the accused has been identified in the TI period, that would not be a ground to accept the identification evidence. That is the identification main is the in the court, and TI period is just conducted to see that the investigation is in the right line and we are proceeding against the accused. But again, this thing, so we are putting a pertinent question to you that whether these two witnesses who are stated to be the injured persons, though identified these petitioner in the TIA parade, whether they have identified him during the trial or not. P10 paragraph 9. ଦେଖିଲେ ସିନା ହବ, ପଚାରୁଛି ପ୍ରଶ୍ନ କହୁନାହାନ୍ତି। PW10 paragraph 9.
The fourth person. The fourth person to whom I had seen in the light of the motorcycle are the person standing in the dock.
PW10 तमन identify करते।
PW10 is there.
Okay, now this man is in custody for more than 11 years because he's 5/9/2013. Is there any criminal antecedent against him? This bail application is coming for the first time or it has earlier come?
First time.
So have you taken instruction about the criminal antecedent?
No, my lord, my lord, my name has not been reflected in the cause title, though I have filed the fresh proclamation on behalf of the appellant, my lord.
केबे फाइल केले वकालतनामा?
Sir,
3rd December 24.
My lord, the date of filing of the bail application.
All right, Mr. Gyanendra Chandra Swai, London Council submits that he has filed his VNAMA on 3rd December 2024. And though the VNAMA is available on record, but his name is not reflected in the cause list. Let the name of the London Council be reflected in the cause list. The name of other council shall not be mentioned in the cause list henceforth. Stop. IA number 3122 of 2024. The London Council for the petitioner submits that the petitioner is in judicial custody since 5/9/2013. Let the London Council for the state obtain instruction about the criminal antecedent, if any, against the petitioner, so also produce the custody certificate. ये जो पीरियड टा जो कोविड पीरियड रे खाली छड़ा ही होतला तेणु सेटा को टिके आनंतु कस्टडी सर्टिफिकेट आनंतु एवं तांकर क्रिमिनल एंटीसीडेंट है ना ये
Lordship's permission,